If we can show that there's a pattern of these things happening again and again and again, right? Now your jury starts going, well, wait a minute. It's not just one. Wait a minute, why does this keep happening? What's supposed to keep these people safe? You want to show, hey, listen, we can't just have dogs running at large. When they run at large, they bite people. We can't have that in our community.
This is Courtroom Stories and Tactics by RVA Trial Lawyers, hosted by Sharif Gray and Niall Abuzaki.
All right, before we get into the podcast episode, I want to take a minute or two and introduce you to a friend and colleague, Jenny Shadini. Jenny is a former prosecutor from Baltimore City, and now she works as a settlement consultant. We work with her often on helping our clients really maximize their results. Jenny, it's really great working with you and having you as a supporter of the podcast.
Thank you, Sharif. Hi, everyone. My name is Jenny Shadini, and I work as a settlement consultant, which means I work with attorneys and their clients in various settlement planning needs, such as structured settlements, whether or not to utilize a trust, how to protect government benefits, and overall providing financial security to your clients.
And Jenny, how could people get a hold of you?
The best way to reach me would be my cell, which is 301-332-1031. Again, that's 301-332-1031.
All right, we're back, RVA Trial Lawyers, and today we have a good friend, Ashley Strandjord. Did I say that correctly?
You did.
So Ashley and I met a handful of years ago. I went down to Atlanta. I always mess up the name, but the Keenan Edge Institute. Is that what it's called? Or
The Keenan Trial Institute.
There we go. So formerly the Reptile System.
Correct.
Ashley has been a long-time teacher in that program. I went down to Atlanta for a course on depositions, and Ashley was the instructor. We met there. We stayed in touch since then, and I think we've become good friends. I hope so.
Absolutely.
It's a one-sided friendship, Sharif.
I count.
You put it on. Yeah, he's putting you on a spot now.
No,
it's recorded.
No, it's definitely
interview,
two ways.
Okay, it's two ways.
I saved his phone number with his name in my phone. That's how you know you've made it. You have not just the number, but you have the name too. So
beautiful.
Yeah.
All right. I'll take
well,
that.
Ashley, why don't you tell us a bit about yourself?
I'm Ashley Strandjord. I recently moved to the Norfolk, Virginia area. I just moved down from the Maryland area. Before that, I was pretty much a little bit of everything. I was an assistant attorney general up in Rochester, New York. I did the civil side of criminal. So I did the habeas corpus on behalf of the state, the time calcs. I did the force feed petitions, all the stuff that nobody else wants to handle. Came down here to D.C. My husband got a job with the DOJ, so we moved. I was only licensed in New York at the time, so I took the Virginia bar exam. Came down and became a prosecutor for D.C. Spent some time there. Loved it.
Best job in the world. Yeah, keep going.
Yeah. Not that we're biased, but it was a great job. And eventually landed at a firm in Maryland, practicing Maryland, D.C., Virginia, doing workers' comp and personal injury. And recently left there to come down to the Norfolk area and keep doing that, but this time closer to family.
And what are you currently doing in Norfolk? So,
personal injury and workers' comp, but mostly dog bite cases.
that's what I wanted to get to.
Yeah, I knew you're plugging for that. So dog bite cases. I feel like there's never a season. Like carbon monoxide cases. I do a handful of those. They come and go, right? People are turning on their furnaces. They're turning on their boilers. Those kind of come in waves. Dog bite cases, they're all year round.
They're all year round, and they're time consuming and very, very emotionally driven.
They are.
On all sides.
Without a doubt.
I remember I've told this story before, but so Niall and I, we both prosecuted Henrico, Niall for far longer than I did. But one of the cool things that I got to do was I got to take over Niall's responsibilities as the animal crime prosecutor. And
he became Paw Patrol.
That's right. Chase is on the case. That was me. And I loved it, by the way. So the Henrico police, or at least the animal control group, fantastic people to work with. But I remember I was doing a preliminary hearing, so in General District Court, for a dog abuse case. There's probably 20 to 30 people watching the preliminary hearing, which is normally like a nothing, right? Like nobody shows up for that, and they normally only take a few minutes because they get waived or come to some sort of agreement. There was a murder trial going on upstairs, and there was like nobody watching that, but the preliminary hearing for this dog abuse case, I was a celebrity. So anyways, it was amazing to me how, as Niall just said, like how invested people are when it comes to animals.
And for that case, it wasn't the charge that people cared about. It was the prosecutor that was prosecuting. So that's why the General District Court had 20 to 30.
Make sure you tell my wife that too, please.
So, dog biting cases are interesting cases. And the reason why they're interesting is because from the criminal side, it's not really criminal. It's like quasi-criminal because it starts as either a dangerous dog or a vicious dog petition that's filed in General District Court.
Right. Or a nuisance dog.
Or a nuisance
running
dog.
at large, which is even less than.
And those are just fines, Right. But then you go to the declaration of either a dangerous dog and vicious dog. So where do you get involved? Are you getting involved are you defending these individuals, or are you actually representing victims of a dangerous dog or a vicious dog bite?
I'm representing the folks who get injured by the bite.
Okay.
Right. Unfortunately, I don't take the cases with the mailman. They have their own federal workers' comp system, so sometimes it's hard, to get involved in those. But folks who are out walking their dogs in their neighborhood and all of a sudden are attacked by 3 dogs running at large, or someone who is delivering, they're an Uber Eats driver, right? They're going to deliver somebody's food and out charges a German Shepherd out of a door and they get attacked. I'm representing those folks.
When you're representing those folks, are you suing the dog owner? Who are you suing exactly?
The dog owner, the homeowner, maybe it's an apartment complex that's involved. I'm suing the apartment complex. If they haven't done the background check for the dog to be there, maybe they have a no pets policy, but somebody's harboring a pet, maybe I'll go after the apartment complex, right? Maybe it's a landlord who's renting out a home and he's renting it to someone and the door's not in the best shape, the fence isn't in the best shape. Maybe I'll go after them as well, just depending on what the facts and circumstances are of each individual case, but always the dog owner, right? Who was in control of the dog at the time?
When you get that phone call, hey, I've been bit by a dog, what are some of the questions you're asking? Like, what are you thinking about to see, hey, is this a case that I can actually add value to? Especially considering, there's the notice requirements, right? Just like any premises case in Virginia.
Right. So I want to know first, where did it happen, right? I'd rather the case that happened in the street. Somebody's out walking their dog in the street and the dog is already at large. They're already roaming around, they're off leash, or they're charging off of a property, right? I'm looking for that. It's a little bit harder when it's a visitor or a friend of somebody else's home. They come in and they go, oh, hey, I didn't know you have a dog. And then the dog bites them. It's a little tougher, but as you know, what are the facts? What are the circumstances going on? I want to know, what are their injuries, right? Where did you get bitten? With children, they always seem to get bitten on their face.
Yes. I've seen that so much.
Oh, God. Sometimes I can't even look at the photographs, but it's always the kid. It's always close to the eye. It's close to the mouth. And that's tough, right? But also, did you get bit on the abdomen? I want to know that, right? I feel like when the dog is going for the abdomen versus your hands or your fingers, that dog is going for the jugular, so to speak, right? That dog is going to get you somewhere to cause some type of injury. Did they get you on the head? Did they take you down? Were you injured in any way trying to get away from that dog? Did you tear your meniscus? Did you tear your rotator cuff? What was happening? I want to know all those things. Was your dog injured in this? Were you out walking your dog? And do you have vet bills for your dog? Because juries, as much as they care about people, they care more about our clients' dogs. They want to know, hey, was the dog okay? How much money did you end up spending at the vet for your dog? And they're okay now, right? Juries can't seem to focus on our clients until they know about our client's dog.
How do you deal with the notice aspect or requirement? I take that back. Because it is a requirement, right?
It is.
There is this concept of one free bite, right? Which I don't think it's as simple as that, but there is still a lot of truth or meat to that statement.
And I would love it if it was like you get your first bite free, but your client had 3 bites. So it was like, yeah, well, the bite to the hand was free, but the other 2, you're on the hook for those. But it's not like that. So going back to the example with Uber Eats, right? I think the notice is already there. You have a dog on your property and you're inviting somebody onto your property, maybe who's bringing food. Instacart, same thing, right? You have a duty. Amazon, you have a duty to secure your pets when somebody is coming onto your property, right? Nobody's saying you have to put them in a kennel inside your house, but you can't let them go barging and running out the door when somebody's coming. I think that's sufficient notice. I've been successful on that. I'm not saying in every court, but there's something there, right? If you're waiting on a FedEx delivery because you run a business out of your house and you think that you put your dogs in the backyard, but your fenced in backyard, you've left the gate open and you're waiting and waiting and waiting for that FedEx truck to come. And when you watch them back down your driveway, this is a real case that I resolved a few years ago. You're watching that truck back up, but then your dog gets out and bites the FedEx delivery driver. Yeah, you're on notice. You're on notice.
You might also be able, right, to piggyback off some of the ordinances we were talking about earlier, right? Like the running at large, or the dog running at large, and then you've got a negligence per se type claim and all that stuff.
Exactly. Exactly.
I have actually found that I haven't gotten too much resistance with dog bite cases when it comes to the notice stuff about the whole 1 free bite. It's just not, and also, to be fair, I don't think it's a great defense. It's a terrible defense.
The question then becomes, what kind of notice are we talking about here, right? That's
right.
That's the question.
Well, and it's also a double-edged sword, right? Because if the dog has a history of issues, there's not going to be any insurance coverage. Provided they were honest with the carrier about what happened. I mean, I've gotten into situations where insurance policies have been deemed void, and there's been separate litigation on that very fact because there was a prior bite by the dog, but the policy holder never actually informed the carrier.
And the question then becomes whether the home owner's insurance has coverage, right?
Correct.
Because we're talking about, just for the listeners that don't appreciate what goes into these cases, when there is a dog bite, yes, you have a personal injury case, but also the police get involved, animal protection gets involved, and there is a question of what is a serious injury. If it's a serious injury to a human being, then instead of being declared, or a companion animal, instead of being declared a dangerous dog, they may be declared a vicious dog. And if they're declared dangerous, then there are some certain loopholes that they got to jump through, and they got to do certain things that are required by the statute. If they're declared vicious dogs, which is either a second bite, or it's a serious injury to a human, or killing another companion animal, that means euthanizing the dog.
Right.
Or removing it to a sister state that doesn't neighbor the Commonwealth of Virginia.
I did not know that.
Yeah, so
really?
I've had a dog. I did a case where I had a dog that we sent off to Florida, and we're like, hey,
just enjoy.
But no, I didn't just do that. I did call Florida Animal Protection, knowing which county. That because they were actually. So I had a family, and they were sending it to their parents so they can live with their parents down in Florida.
Okay, yeah.
So I called that particular jurisdiction, spoke to Animal Protection, sent them the declaration. I was like, hey, just beware. I did my part.
Wow.
Yes.
Isn't it amazing, though, how prevalent these cases are? And we talk about this fairly often. I mean, even like sex assault, right? Like, who would guess that sex assault in and of itself is a practice area for civil lawyers, right? Not criminal. I mean, of course, the criminal is very prevalent, unfortunately, but there are firms who do nothing but sex assault cases on the civil side.
Right.
And to some degree, my impression is that your firm does probably the bulk of dog bite cases in Virginia, or definitely has a significant amount of them.
We do. And you know what's interesting? When folks call up and they ask, one of their first questions is, should I get the rabies vaccine? Right? Well, I can't give you medical advice, right? But this is top of mind to folks. Then the next thing that always floors me is how people say, well, the dog's in quarantine with animal control, and animal control is going to call me. Folks don't realize that the dog gets to stay with the owners for 10 days. When they hear that, the immediate reaction is always, what do you mean they get to stay with their owner? What do you mean that's quarantine? I thought animal control took the dogs. And that sort of riles people up. I haven't figured out why yet, but it amazes me.
Accountability. They want accountability.
Yeah.
Yeah, I mean, well, that's in.
That's a good point.
I've taken many intake calls, right? And obviously, compensation that recognizes the full and fair value was taken from someone's health, quality of life is important. But the number one thing that people care for is they want accountability. They want accountability. They want deterrence, right? And let's talk about that deterrence piece. And I'm sure this will kind of tie back to some of the training that you and I have both done. But how do you make a dog bite case not an event case, more of a systems type case? And I recognize you're going to need certain facts to do that.
Sure. So I think you have to show, that this could happen to pretty much anyone, right? Who's next? So you have to show that there's X amount of dogs that are around, right? And that this dog belongs to a larger walkable community, maybe. Let's say let's roll back. Let's pretend somebody is bitten while they're out walking their dog, right? They're on their normal morning routine. I think if you start asking your client, well, how many other folks do you typically see in the morning when you go walking down the street? What times are you walking? Are you walking at 5 a.m. when it's dark and you need a flashlight and you see 2 other people? Or are you walking your kid to the bus stop and you got bit on your way back home? Like, are there school children out, right? This could happen anytime, anywhere, USA. And I think it's really driven based on facts, right?
And why is it important for our clients for us to go down that route and try and explore those types of facts?
Well, I think the jury then understands a little bit more like, oh, hey, this isn't just what happened to Joe over there who's prosecuting this case. This is a problem. This could happen to my kids when they're going out to the bus. This could happen to my grandson. He delivers for Uber Eats, which this is not a plug for Uber Eats, by the way. So it's just sounding like it is, though.
I like DoorDash more. I'm just.
But I think you have to get the jury's mind ticking. Okay, well, where would they be? Where would they be going? Who in their family, in their network, would be out doing these things? And sort of getting them to see it's not just that person who got bit on the face. It's anybody, right?
I mean, that's one of the things that I used to do in voir dire as a prosecutor, right? I get up and I'm like, well, the reason why I'm standing up today is because I'm representing this community. And something happened in this community that has led to a prosecutor standing up and saying, hey, we got to do right. And what you're doing there is saying, hey, something happened to the community. And it could happen to someone else.
Right.
If you don't take action in a certain way without saying, hey, if you don't take action in a certain way, right? So you're kind of saying, hey, it's not just this one person.
Right.
This is a neighborhood. There's other people walking in this neighborhood. Your children can be playing at a friend's house in that neighborhood.
Correct.
Anyone can be a victim. So what do we need to do to put protections in place to prevent that from happening in the future?
Right. And it's hard because, like you said, you can't use that language in the courtroom, right? It's really hard to say community. So instead of saying, my client's name, Mr. Smith, was bitten by a dog, I might say a walker here in Henrico County. And that brings us to a broader listening audience, right? The jury goes, oh, my neighbor next door, they walk every day. It could happen to them, right? It's not just Mr. Smith. It's a little bit more.
Using the rules of evidence when you get objections to this approach, which I'm confident you do because I certainly do. How do we tie it in? How do we say, Judge, this is why this is permissible in a non-punitive case?
You mean the language that I just used?
Yes.
Yeah, I think it goes more importantly to relevance, right?
The question is it relevant?
It is.
Yes.
Yeah. And the judge says so. So it's relevant, right? We go right to Rule 403 and the balancing test, right? We are looking at does the probative nature of what we're saying, what we're trying to bring in, does it outweigh any prejudicial effect? If yes, it comes in, right? And be ready to argue that.
Do you ever try and make the foreseeability argument when trying to spread the tentacles, right? Like that it's our burden in some sense as the plaintiff to say, we have to prove that the harm was foreseeable based on this type of negligence?
I think yes. It's easier to do with some cases than others, right? Maybe a dog running at large, that's easier to do if you have prior citations or a nuisance dog, depending on the facts and circumstances, versus, hey, this is the first time out of the gate. I don't have a whole lot to go on. I don't think it's fair to say, hey, it's foreseeable that this dog will bite just by virtue of you having a dog as a pet. Does that make sense?
It does make sense.
Okay.
It does make sense. Can you talk a little bit about what a system failure is and why we're pursuing that?
Sure. So instead of just having a one-off type of event, folks don't really care about something bad that happens once. They're never going to see this as something that they have to take action for. By the time that it's coming to a courthouse, it's what, 2, 3, 4 years old? Nobody cares about that. But if we can show that there's a pattern of these things happening again and again and again, right? We show, like, let's switch gears, right? From dog bites, let's switch to perhaps construction site cases as well, right? You show that, your client fell from one story to another story on a construction site. And you say, okay, well, listen, it wasn't just my client who fell. On this construction site alone, there were 5 other falls on this site. And in DC, in that year, there were 63 other falls. Now your jury starts going, well, wait a minute. It's not just one. Wait a minute. Why does this keep happening? What does this keep happening? What's supposed to keep these people safe? And how do we prevent this from happening? Because we can't have people falling all the time. Going back to dog bites, you want to show, hey, listen, we can't just have dogs running at large. When they run at large, they bite people. We can't have that in our community.
That makes sense. And coming back full circle in some respects, sounds like prosecution, right?
It is. And, that's why localities have the leash ordinance, right? You don't want dogs running at large. And that's why localities get involved and fine, and they declare dogs dangerous or vicious, because also the question of, hey, how do we put the community on notice? And you have individuals that are just trying to do their job and come in and either deliver whatever for Amazon, FedEx, UPS, USPS, whatever it is.
Uber Eats.
And then they're bitten, and they have to deal with that injury, and then fair value of that injury comes to you.
Right.
Well, yeah, and it's the accountability and the deterrence piece. And to me, that's not that I don't get a lot out of representing a person and trying to get the full value for what's been taken from them. That's obviously very important and meaningful and purposeful work. But that extra element of thinking that the work that we're doing could potentially save the next person, right? Or stop that next kid from having the scar under their eye. Right? Like, that's, to me, why this work is so incredibly important. And I think it's something that, frankly, we lose sight of. And it's something that I know on the plaintiff side, we need to be very cognizant of when we walk into that jury room, right? I mean, what's the phrase? Like, Bubba doesn't care about your client, right? They don't. They care about themselves. They care about their community. And I think oftentimes, kind of like a criminal defense lawyer or a criminal defendant in a criminal case, we as plaintiff attorneys come in already a little bit behind. Why didn't they settle this case? They're here because they're greedy. They just want more. They're looking for their lottery ticket, right? I hope I'm wrong. And that's why we have focus groups and we can test these things. But I'm always very vigilant about that type of stuff.
I think you have to be, right? And you can't tell the jury, we're here because the defendant never answered my letters of rep and I had to sue them in order to find out their homeowner's insurance, right? I can't say that, right?
It's usually the prosecutors will have a copy of that homeowner's insurance or the animal protection, right? Because so that's one of those things that I'm not sure many people know, but when the dog's declared dangerous, they got to do certain things, and including fencing, signage, get an insurance policy that covers that. And it covers that. But if not, then sometimes the homeowner's insurance is used because no insurer is going to be like, hey, you have a dangerous dog, let me insure your dog for you. So all that plays a role, but also your case gets much stronger if a dog that has been declared dangerous then goes out and bites
again.
Right. And that's one of those things where if there's a declaration and the owner doesn't comply, then it becomes criminal.
Correct.
So it's not civil anymore, even though it started civil in nature. Now it's a class 1 misdemeanor.
Oh yeah, as a plaintiff's attorney, I love when criminal cases do well, right? But Niall and I there's a case that we're working on that now has just happens to be related to the person, and the lady hit Niall's father, and she was drunk, and then 2 months later, another DUI.
Another DUI.
I mean, talk about punitive damages and someone not learning their lesson and a danger to the community. I mean, that's it. That's the definition of it, right?
Yeah.
And so I think in cases like that, we can really add a lot of value, not just monetarily, but also like, what does our community think about this, right? Like, why isn't the person getting the picture, right? And really trying to make a difference and give the jury something that they can fix, hopefully.
Hopefully once and for all, you know?
Hopefully, right? That's the hope. And I think prosecutors now have that same goal, right?
Yes. No, you got to make things right, right? You wake up every day to say, hey, how can I make things right? My job is to do the right thing. That's
true.
what prosecutors do.
That's right. And make sure to pad the case so the plaintiff's attorney can take it
and run with it,
and
right?
run with it, right? Do all the work, do all the investigations.
Oh,
And you just submit it for you.
Yeah, because the prosecutors have all the time to do that, too.
Exactly.
That's right.
Yeah.
That's right.
Very few files to contend with.
I'll give you a referral fee, I promise. But no, it's great. So, well, in your new role, Ashley, so my understanding is a lot of dog bites, obviously general PI, some workers' comp, but construction too.
Construction, too. Love it.
And I got my LLM and trial ad in Pennsylvania, and I remember some of the sponsoring firms for the program very big into construction law, significant. I haven't seen the same in Virginia. Why? And when I say construction law, I'm referring to plaintiffs' injury construction type cases, not business to business versus business type litigation.
Right.
Is it our workers' comp bar? And when I say bar, not the group, but like the restrictions that limit our ability to bring a lot of construction type cases?
No, I think we can, right? I just don't know that folks really heavily advertise for it, or maybe I'm just not looking in the right places. But they're a little bit more complicated, right? Because if, let's say, a subcontractor gets injured on a construction site, they trip over a hose, they fall from one story to another, their foot slips into a running auger. It's happened before. I've had that case. Somebody gets hit by a swinging load on a crane. I mean, really, the whole gamut, right? They have a case against their own employer, who's a subcontractor. They have a workers' compensation case. It's awesome, right? You can start investigating your case against the general contractor of the entire job site and building that case while you're getting your client the medical care and treatment that they need paid for by workers' compensation. You're getting them their lost wages at 2/3 of their average weekly wage. And you're working technically with workers' comp. They have a subrogation adjuster, right? They want to get their money back. Workers' comp is saying, hey, whoa, we wouldn't have had to pay this money if somebody else wasn't at fault. This isn't necessarily like a no-fault thing. We want our money back. My job is to say, hey, whoa, I'll get you your money back. Don't enter my case. Don't implead into my case. I have your lien. I know what your lien is. You help me. What's in your investigative file? What have you found out about why that hole was there? Why was that hole uncovered? Why didn't that hose have a warning that my client could trip over? Whatever it is, right? So it's rewarding in that respect. You can get them what they need now while you build to that personal injury aspect that everybody thinks about as pain and suffering.
Makes sense. And from my understanding is that some of these injuries on these construction sites are
they're
just horrendous.
Catastrophic. It's terrible. It's terrible. I mean, I've dealt with cases where somebody has fallen, thank God, only 2 floors. And by sheer happenstance, there was something covering the chute for the elevators that went all the way down to the bottom. I mean, they're terrible cases.
The individuals that are usually can be held liable are the contractor, subcontractor, the developer, and the architect. It's kind of hard to hold them accountable.
We've tried, right? We've tried to sue them before because, as a plaintiff's attorney, you don't want to leave anybody out of the picture, right? You want to say, okay, I think it's all of these people. I think it's the developer. I think it's the architect who planned this. I don't know what negligence they really have. After doing it a couple of times and seeing it, I don't know what's there. I don't know how to hold them in. What was their duty? What did they breach when my client was struck by a swinging load on a crane? That's hard to say, right? So typically we let them out. It's really just we're stuck with the two general contractors or the general and the sub-general contractor, and we go after them. They typically implead our clients' employers for contribution and indemnity purposes, but I can't, as my client's attorney, I can't sue the employer because our only right of remedy is the work comp system.
Okay.
Yeah.
Well, something that just hit me, it's like, wow, personal injury. I mean, I think the average person thinks, they see some billboards on the side of the road and get in a car wreck, call a personal injury lawyer. Dog bites, construction cases, sex assault, carbon monoxide, negligent security. I mean, the variety in this type of work. Maritime, right? Which you and I talked about that the other day, which I have, no clue about. But FILA cases.
FILA cases, right.
So
people dedicate their whole careers to FILA.
Cruise ship. There are firms who do nothing but cruise ship stuff.
Yes.
So it's really incredible, this line of work and the variety, the creativity. What is it, Ashley, for you that keeps you doing this type of work?
I really love helping folks, right? Folks who have had their worst possible day. I love that. I just had a client today. She's a current client, got involved in another wreck. I'm her first call after the dust settles. And she goes, hey, I've already gone to the hospital, but I need you to know I've been in another wreck. I want you to help me because you've been helping me with this stuff. I love that. I love being able to solve people's problems, hopefully creatively, hopefully before we get to trial. I'm not adverse to trial. In fact, I really love trial. I really love trial.
And why is that?
I love how when you have so many things going on all at once, right? You have so many things that you could possibly be thinking about, so many different ways, so many different avenues that this could possibly play out. My mind is quiet and I can just focus. And it's like, this is what my client is asking me to do, right? Bring them justice. And they get to see me do that. That's pretty cool. That's pretty cool to me. But if I can solve somebody's problem creatively before that, and they're happy, and I've not only met but exceeded their expectations, that's a great day for me. I love that.
That's awesome. Yeah, and I joke with Niall all the time that I'm sure there's a part of him that misses the trial work, sitting on the bench.
Of course. And that's something that every judge that was a trial attorney before they became a judge, you ask them, do you miss being the advocate, being the voice for justice? And more often, those trial judges are going to say, yes, I do. There's something about it. And, I hear a lot of judges, when they get on the bench, they want to object. And
Right.
Thankfully, it hasn't happened to me where I'm making objections, in the middle of a trial. But that's the trial attorney in you.
Right.
Right.
And some people are called to it, right? Some attorneys love trial work, right? Some want nothing to do with it. And that's okay too, because that's part of personal injury. You can do it. You cannot. It's okay.
And we love trial work. And
we love
trial work. And that's probably what I miss the most about prosecution is being in court.
Every day.
Every single day.
Yeah.
And you are in court every single day. And just for those that want to be trial attorneys that listen to this podcast, being a prosecutor or a public defender is the way to go if you want to be a trial attorney and if you want to get comfortable on your feet. But keep in mind that every time you stand up in the courtroom, you're building your credibility. And we've talked about this, and a prominent attorney in the Commonwealth of Virginia once said that you can spend your whole life gaining that credibility, and you can lose it instantly in one case.
Instantly.
So be that trial attorney, build your credibility, and then go do whatever you want to do, because I'm looking at two personal injury lawyers that are very successful and doing great work out in the community, representing those that need help. So talking about what you do, today you're going to be doing a little more than your typical personal injury cases.
Yeah.
And I want to kind of bring you into the rules of evidence.
Sure.
Well, can we give a sneak peek about like what's happening this evening?
Sure.
Let's do it.
I'll let you start.
You want me to start?
Yes.
All right. So this happens more often than I think I'd expect, but we have been given an opportunity to present to the Inn of Court, the Lewis F. Powell Inn of Court here in Richmond tonight. And Ashley is the star. So it's going to be Ashley leading the way on a handful of rules of evidence that I recognize that probably doesn't sound exciting, but I can guarantee it will be exciting and it will be entertaining because if you get into this stuff and to see how these tools can be used, it can be good stuff. And then Niall and I will be there really just to look good, right?
I mean, that's it. I'm just going to
Color commentary.
Exactly.
Yeah.
That's why,
I've got the play-by-play.
I wore a navy suit just to complement the red right there.
It's
and
perfect.
Sharif wore the khakis just to kind of.
We've got the red, white, and blue thing going on today.
Yeah.
It's great.
I'm not good at dressing up like an adult, so I might have to. I think I did bring a tie.
I see a tie and a jacket.
And a jacket.
We're good.
So,
anyways,
the rules of evidence, they are so powerful, but so often overlooked by trial attorneys.
Absolutely.
Yes, to be a great trial attorney, you got to have...
judges.
And judges. I agree with that. To be a great trial attorney, yes, it's the charisma, the way you stand, the way you present, the way you move about the courtroom, the way you direct, the way you cross, the way you tell stories. But before you get to that, it's how can you frame your case with the best evidence that you have to present to the trier of fact. And actually, often I see that attorneys don't do that. And I saw it when I practiced, and now I see it from the bench where I'm like, why aren't they objecting?
Right.
The rules of evidence are right there, right? It's you open up that booklet, and there's one thing that I know is that every judge before, and I'll tell you this, every judge, when we go through a pre-bench, and that's before we take the bench, we're giving the rules of evidence booklet, and it's the same booklet that Sharif has.
Yeah, it's right back in my trial bag over there.
And
I've got it too.
And that you got.
Yeah.
So if you bring that with you to court,
Absolutely.
and you make the objection and be like, Judge, let me direct your attention to Rule 2:403 of the Virginia Rules of Evidence, and it's on page, and you can even tell the judge what page it is because you have the same book.
Yep.
How does that look in front of the jury? So let's talk about the rules of evidence and the power of the rules of evidence, because judges, we've talked about it often, want to be led, and if there's an objection to a rule, you want to direct them to that rule. Correct. And tell them why a piece of evidence shouldn't go in. So why is the rule of evidence overlooked first? And second, how can practitioners become better trial attorneys by familiarizing themselves with the rules of evidence?
I think it's overlooked because of just generally how most folks come to practice or do trial work, right? If you're in a big law firm, right, you're in big law, it's probably, 7 years until you get to maybe take a witness, right? I mean, those are the horror stories that I've heard. You're focused on doing your witness, right? You're not doing opening, you're not doing closing, you're not doing whatever. So it's probably just the unfamiliarity. I think for those folks who do want to do the public defenders, they do want to be a prosecutor, they do want to be in trial all the time, they are the ones that are knowing the rules of evidence. What can I do, right? Because the rules of evidence are, I like to say, they're a sword and a shield, right? What can I do and what can I use this for, right? How do I defend my case and how do I weaponize my case with the rules of evidence? Is there a fact that I absolutely have to get in? Maybe it can be judicially noticed, right? We're going to talk about that tonight. I love judicial notice. I've said this for years. I love it. I think it can help really streamline your case by knowing how to do it, right? I think there's a lot of attorneys out there, and I've seen it myself, and Sharif, I'm sure you have too, where attorneys, they go through the motions, they lay the foundation for the piece of evidence, and they get it admitted, and then they do nothing with it. Like, it's in evidence, right? But you didn't publish it to the jury. You have your witness use it at all. You didn't have anybody mark it up. What was the purpose of that, right? Each piece of evidence, it's great that it's admitted. That's half the battle. But now you have to use it, right?
And often we see that, hey, they're so excited that they got the piece of evidence in that they lose sight of the purpose behind
Right.
it.
And just because you can doesn't mean you should, right? Just because you can get it in, just because it's admissible, just because it's relevant, doesn't mean that it necessarily needs to go in.
So we often hear objections to hearsay.
Yeah.
And hearsay is one of those rules of evidence that as soon as you hear, hey, well, he told me, objection, hearsay.
Right.
And sometimes judges, as Sharif noted, sustain it right away, but that's not
It's not it.
That's not it.
Right. So you got to know, what is hearsay? You can, out of court statements are allowed in court, right? Out of court statements are allowed. Your witness, your plaintiff, your defendant can testify, he told me that, and it's not hearsay. We're only concerned when it's for the truth of the matter asserted. That's the key part, right? People hear, he told me, well, she said, well, my neighbor, and they pop up out of their seats, and you go, oh, God, now I got to educate, opposing counsel, and maybe even the judge, that this isn't actually hearsay.
And
it does come in.
truth of the matter asserted.
Isn't a fun phrase, isn't
But
it?
it is. But the thing is, first, it's got to be an assertion. So
Correct.
the question then becomes, the other day, an attorney object to a question. I'm like, well, tell me, is a question that was asked out of court, is that an assertion? It can be,
Yeah.
but
Are they trying to communicate a fact?
exactly.
Right.
Or is it a question?
Right.
And the attorney kind of sat back and thought about it. She's like, well, I don't know if they're asserting anything with it. Then I was like, well, tell me how then it's hearsay.
Right.
And is the truth of it important?
What's at issue? Right.
You're a walking piece of crap. Is a human a walking piece of crap? And what are they asserting with that, right? So that can be hearsay and it cannot be hearsay. And people lose sight of that as soon as they hear an out-of-court statement.
Right.
They object, hearsay, and then you have judges, sustained, move on. Well, judge, hold on, give me a second. Let me make the record. let me tell you why it's not hearsay.
Right.
And often that's what leads to some practitioners, when they object, they make a speaking objection because you have to know the judge.
Right.
If the judge doesn't know the rules of evidence, instead of just standing up and saying objection, hearsay,
Right.
you have to go a little farther.
Absolutely.
And when your response, you have to give a little more.
Absolutely.
It's
And,
also- yeah.
you
Go
know,
ahead.
we just talked about this. I think, last week we talked about this. There was a Virginia, I think it's a Court of Appeals case now, that came down when the judge says, hey, listen, I got it. Your exception is noted for the record. And the case went up on appeal. And the Court of Appeals said, no. Having the judge say that your exception is noted for the record doesn't preserve your objection for purposes of appeal. And I think that's really important for practitioners to know, because your objection has to be contemporaneous and you have to state it with specificity. So technically, under the rules, just stating objection and then having the judge say, overruled or sustained, that's not really with specificity. We all may know what's going on right then and there, kind of going back to the idea that everything is flying around in the time of trial. But when you're focused on making your record, you've got to make your record fully, accurately, and with specificity at the time.
And the judge doesn't make your record. Go ahead.
Yeah. I don't know. I mean, who am I? I'm not, by no means am I ever qualified to be an appellate lawyer, let alone a court of appeals judge. But to me, that's a little bit of a harsh standard, right? Because,
is.
I mean, if you're really in the heat of it, and you have to say, sorry, judge, I got what you're saying, but I could care less. I got to do A, B, and C.
Right.
That's tough.
Well, I think it goes back to being prepared for
Sure.
your trial, right? You probably want to have a copy of that opinion tucked away somewhere in your trial notebook because, God forbid, it comes up. You can say, Your Honor, may we approach? And then you show them and say, listen, I appreciate you noting it for the record. That's helpful. However, I need to make my record right here. And I'll just do it here, right here while we're at the sidebar. It's fine.
Yes, and it's on the attorney to do it, and sometimes I'm even say, I'm not going to approach. I'm going to ask for a sidebar, take the jury out, and I'm going to note it on the record because sometimes when you approach,
Right.
they're not recording. They're
Right.
not transcribing. Sometimes, no, I'm going to have the jury step out and judge, this is what I got, cite the case, go to the ruling, and just flush it out for the court. And I'll tell you, I've tried cases where I've had a trial attorney and an appellate attorney. Mm-hmm. And the appellate attorney did nothing but argue the motion to strikes, and argue objections. His job was just to make the record because they were like, hey, even if we lose down here, which they did, we're going to go on appeal. All right.
Right.
So it's those cases that you gotta, you need someone, and Sharif touched on it. There's so much going on, but it's the onus is on the practitioner to make the record, and you got to speak to the record and I'll make the argument. Just speak to the record and make sure it's there so you can give the Court of Appeals the argument to actually find in favor of your client.
There's a few practical takeaways here that maybe they'll come up tonight as well when we're doing that talk. But one thing that I definitely want people to know is that you don't have to wait till mid-trial, right? Like that's why we have motions practice.
Absolutely.
Right? That's why we can submit briefs. If we know that there is a contentious issue, then you got to shape the battlefield. You have to. The last thing you want to do is be in front of a jury and be going back and forth with the judge. And then, of course, the jury's watching. That's not a good thing.
Right.
And so I guess the two practical things that I would want to make sure are crystallized are, one, and we can talk about this more, but it's okay to file motions. In fact, you should. And you should come in your trial notebook with those motions, with the briefs, with the appropriate case law, because if you know your case and you know what issues are going to come up. Another thing, which is a big, big, big important point in my eyes, is it's almost meritless or pointless to be arguing your objections in front of the jury, because then the jury is hearing exactly what you either don't want them to hear or you want them to hear, right?
Well, exactly. Depends which side of that.
Sidebars are incredible. Asking for to be heard outside the presence of the jury is a good skill, because once the bell's been rung, it's done.
Right.
And often I say sidebar because I don't want the jury to think that me, who says, hey, can we be heard outside of the presence of the jury, the person who's asking for it is the person that's hiding something from the jury. Right. So I just say, Judge, we're requesting a sidebar, and the jury's like, sidebar? Where's a sidebar? What does that mean? Right. But it's just, you don't want the jury to.
Right.
Yeah, and it all comes back to the can v should too, right?
Yes.
I mean, there are times where something's objectionable and I'm letting it go because this is great,
Right.
I mean,
without a doubt, and sometimes something that's objectionable, if you don't object to it, then it won't carry the same weight that you've given it, right? Because sometimes the jury doesn't know the importance of this piece of evidence until you say objection, and then they all perk up and they're like, oh, what's going on here?
Right.
Tell me, what should I be listening to?
Right. I got some great advice, I don't know, a couple of years ago, that when we stand and make our objection, right? Don't be lazy. Don't just do it from your chair. That drives me nuts, right? But when you stand, it serves two purposes. It breaks the jury's focus from maybe the witness or maybe the questioning attorney, and it draws it on you. And it sort of says, okay, wait a minute. There's a break in the action. Something important has happened, and it's a key to them. So you should always stand, right? And do that, because they're saying, okay, cut, look at me, something's wrong. And then usually we get the counsel, will you approach? Yeah, okay, we'll approach, we'll deal with our objection, and then the jury does their stands and stretches and then goes back and they go, gee, I wonder what happened there, but that's stuck with me for so long, because the judge has said, this is why we do it. It's not just because we're being formal. The jury is the one that's trying to follow along and follow this story.
And I agree with that. And also, often if someone makes an objection, and I don't do that as a judge, I do it when I teach at the law school, my students want to make an objection in class and they don't stand. I'm like, I didn't hear you. Mm-hmm. And they'll speak louder. Objection, hearsay, Your Honor. Can't hear you. Objection, hearsay, pursuant to 2:803. Can't hear you. Stand up. And you're right.
Yeah.
There is something to that. There is something to that.
Remember, guys, right? Not that I need to remind you all, but we live with these cases sometimes for years. The jury lives with these cases for a few days, maybe a couple weeks, right? The presentation is extremely important.
It is.
And it's something that I think is underserved when it comes to training lawyers. And I think in some respects, and now correct me if I'm wrong, but a big reason why we do this podcast, we've got a handful of reasons, is to try and help serve that part of lawyering, right? Like to say, guys, like the presentation matters. How you go about examining the witness or telling the story or doing simple evidentiary things can make a very big difference to your client.
And even before that, how do you speak to the sheriff? How do you speak to the courtroom clerk? The jury's always watching, right? The jury's always watching. If I don't know the sheriff in the courtroom, I usually write their name down at the top of my trial notebook so that I can address them appropriately when we come back in, because it matters, right? It's also basic human decency. So just be a decent person, right? Treat everybody with respect.
Ashley, if the deputy sheriff is smiling at you or nodding at you while the jury's watching, you gain points. If the judge nods with you, and I often, every time I get up, I nod and thank your honor, and I try to put a smile in, you get points. Even me, when defense attorney does not know how to use the Elmo in court, I stand up. I'm the first to stand up, and I help the defense attorney. Yes, that's me. I'm a helpful guy, but at the same time, I know the jury's watching. They're going to say, you know what? Yeah, they're duking it out, but this is a good guy.
Right.
He's a good human.
Right.
He's doing what should be done. And, and those little things matter in court.
They do.
You can't just go in and act like a lawyer.
Right.
You got to be a human being first.
Right.
And people lose sight of that, and we often say it. Be human. Let your humanity define your practice. Not your practice define your humanity. And we lose sight of that.
Absolutely. What is the saying in the training institute? It's we want to be off code.
Yeah, we want to be off code, right? We don't want to be seen as that, greedy plaintiff's attorney, right? We want to be the teacher. We want to be someone that the jury is looking to learn from, right? They want to learn about the case from you, and they want to learn what they can do to help solve your client's problems.
This has been a lot of fun, Ashley.
Same here.
Before we wrap up, if you could go back in time to when you first became a lawyer, what's some advice that you'd share with yourself?
Oh, gosh.
Uber Eats is an acceptable answer. Partly acceptable.
I don't think Uber Eats was out when I first started practicing law. You know what? I would probably tell myself, you have built a fantastic trial notebook, because I had at the time. I built it in law school. You have a fantastic trial notebook. Just go out there and try the case. Try the case. Don't be afraid, right? Even today, I still get a little nervous before a trial, right?
Every trial attorney should.
Yeah, I do. And I kvetch around the house, and I moan and groan to my husband, and he goes, Junebug, that's what he calls me. He goes, Junebug, you love this. You're going to be great. And then I keep moaning and groaning. And then on the first day of trial, when I come home, he goes, I'm like, and then I said, and then you're never going to guess. And then guess what happened when I did? And he goes, yeah, because you love this. So just go and try the case. That's my best advice.
For people who also want to learn to love this work, and I believe it takes time, right? Like I don't think it's something, because there's a learning curve, right? Like you need to, it takes time to get the experience, to feel comfortable in the courtroom, to learn the rules of evidence. What are you telling young lawyers to do if they want to be a trial lawyer doing the type of work that you're doing?
Go work and learn with somebody who loves trial work. You're never going to fall in love with it any other way. Go sit in a court. Go sit in GDC, right? Go sit in General District Court and watch criminal. Go watch civil docket. Go watch the traffic docket if it interests you, right? It's kind of exciting when somebody's license gets taken away because they were doing 103 on 95 South at 10:33 at night. That's exciting stuff.
Yeah.
But I mean,
we see 115, 116.
Right. But I mean, listen, go watch it. Go watch other attorneys be attorneys. I do that. I show up early, right? Before my civil docket is called at 10 a.m., I show up for the 9 a.m. docket. I don't care that it's criminal. I like to watch it. What am I going to pick up?
Actually, that's great advice, because not only are you watching the people in court,
I'm watching the judge.
Court. You're watching the court. Mm-hmm. You're watching the clerk, how she or he interacts with the court. You're watching the deputies. You are getting an appreciation.
I am.
For this arena.
Yep.
Right? That you're going to be
Today.
exactly
Today.
Today.
What is the judge's point of view? Did they just sentence someone and they had a real tough time about it and it was a super contentious sentencing? Okay. Might tread a little bit differently.
Especially on the discovery dispute, right? Like,
right. Like,
don't need to be as fired up about this one right now.
Might tone this one down. Is the 9 o'clock docket spilling over into the 10 o'clock docket? And now the 10 o'clock docket isn't going to get called until about 11:15. I'm not going to be the one to stand up and say my motion is 20 minutes. Are you kidding? No, I could probably do it in 10 and get the same result. It's going to be good.
And the court will appreciate it if you
hashed it out beforehand, right?
Settled the case?
Always settle the case, right?
Yeah.
Get it done. But if you point out the obvious, Judge, I do see that your 10 o'clock docket or 9 o'clock docket has run into 10 o'clock, so we're going to be a little more succinct to the point. Would you like us just to proffer this or do this? And the courts appreciate that because they're like, this person is considerate. And then let the judge lead the way and be like, hey, if it takes an hour or 2 hours, Judge, you dictated that you wanted it this way. We try to, facilitate it in a way and simplify for you. So yes.
This has been great. Thank you so much.
Thank you for having me.
So,
appreciate you, Ashley.
And let's get working on the PowerPoint. Right?
Let's do it.
Awesome. Thank you, Ashley.
Thank you.
Thanks for listening to Courtroom Stories and Tactics by RVA Trial Lawyers. Hosted by Sharif Gray and Niall Abuzaki. Please subscribe and leave us a review on Apple Podcasts, Spotify, YouTube, or any major podcast platform. Together, we're building a tribe of trial lawyers to remind the world what human life is truly worth, one verdict at a time.